Hello everyone, I'm Leonard French, your favorite copyright attorney, and today I thought I'd make a video for you about the Bible Reloaded lawsuit, which happened last year around August or September or so, after the Bible Reloaded channel had some DMCA takedown problems, would be a polite way of putting it. If I understand the situation correctly, the Bible Reloaded makes some commentary on Christian films and things like that. Generally does not use anything that I would consider to be outside of a fair use, and they got some DMCA takedown claims anyway. So they made a video about it, they opened a GoFundMe, they sued the Christiano Brothers for these takedown notices, and I thought I would go over the lawsuit in a video today. So join me, and we'll see what's going on. So the first thing I thought I'd talk about would be the docket here, and I'll put this up on the screen, full screen here. This is the Jacob Daniel Fleet et al. Versus Christiano Film Group Inc. case. I did my best to omit the parties' phone numbers and email addresses and anything, so hopefully no one will be upset with any accidental doxing that I've done this time. So on October 3rd, there was a complaint filed by a local attorney in the Central District of California, and through the video game attorney Morrison and Lee. And so a complaint was filed there, and I thought that would be a good place to start. So here's the complaint filed in the Central District of California. Jacob Fleet and Jacob Spatz doing business as the Bible Reloaded against the Christiano Film Group doing business as 5 and 2 Pictures. The complaint makes claims for a DMCA misrepresentation, for unfair competition, and for intentional interference with contractual relations under the California state common law, and demands a jury trial. Plaintiffs Daniel Fleet and Jacob Spatz doing business as the Bible Reloaded, by and through their attorneys of record, complain of defendants Christiano Film Group doing business as 5 and 2 Pictures, hereby allege as follows. Plaintiffs are the well-known creators and co-hosts of a video series, The Bible Reloaded, that provides comedic commentary and criticism about religious-themed content, including films and literature, to an online audience on the youtube.com website. Plaintiffs use their channel not as a forum to politicize or preach their beliefs, but to merely provide entertainment to their viewers. In response to certain videos published by plaintiff, including videos that merely discuss factual matters, defendants wrongfully used the takedown provisions of the Digital Millennium Copyright Act in a knowing and willful attempt to thwart plaintiffs' right to free speech under the First Amendment. This case arises as a result of defendants' unlawful takedowns made to stifle public discussion and criticism of defendant Christiano Film Group's films. Defendants' frivolous accusations are flagrant abuses of the law and directly caused YouTube to remove content from plaintiffs' platforms to plaintiffs' severe detriment. The wrongful conduct caused irreparable harm to plaintiffs' reputation. I'm going to skip past some of the jurisdictional stuff. Factual allegations. Plaintiffs first met in high school while working at a popular fast food restaurant chain in Michigan. The two developed an instant chemistry, and their funny and witty banter amused not only themselves but their coworkers as well. The duo decided to start recording their conversations and publish them to the internet. On or about January 2012, plaintiffs created their own channel on YouTube entitled The Bible Reloaded. The initial idea was to simply publish the everyday conversations between plaintiffs for pure entertainment value. The channel then developed into an atheist Bible series where the two read passages from the Bible and provided their commentary from an atheist point of view. Approximately 2 years after starting the channel, plaintiffs began publishing movie reviews, which have become the most popular and highest-grossing videos on the Bible Reloaded. Since January 3rd, 2012, the series has been published to plaintiffs' own channel, which has been hosted by YouTube, an independent web hosting company. Then they talk about some of their views, 16,000 subscribers, then 60,000 subscribers, then 142,000 subscribers. On April 8th, 2016, plaintiffs published a 41-minute video of the Bible Reloaded on YouTube entitled Atheists Watch A Matter of Faith, the quote-unquote first video. This first video consists of a review and critique of a movie called A Matter of Faith. During the course of the video, while providing commentary, plaintiffs show still shots of the movie and short clips of the film. Plaintiffs' commentary is focused primarily on the religious concept of evolution versus creationism. The first video was an instant success and viewed approximately 20,000 times on its first day. On or about April 20th, plaintiffs were notified of a takedown notice submitted by the Cristiano Film Group demanding that the first video be removed on YouTube pursuant to Section 512 of the Digital Millennium Copyright Act. The first DMCA notice claims that the first video contains unauthorized use of the copyrighted A Matter of Faith motion picture, and therefore it infringes the copyright. Defendants were later informed that the first DMCA notice was submitted by Salvanayagam on behalf of CFG. A true and correct copy of the first DMCA notice is attached. So this is what YouTube's notification looks like when they receive a DMCA takedown notice. They link to the video and tell you that it's been taken down, and then give you some steps that you can take to submit a counter notification. Upon information and belief, CFG is the film production company that created, produced, and released A Matter of Faith. It is owned and operated by brothers Rich Cristiano and Dave Cristiano. Besides A Matter of Faith, CFG produces and releases other religious-themed content, including theatrical feature films and websites promoting those films. Further, on or about April 20th, in response to the first DMCA notice, YouTube removed public access to plaintiff's video. Therefore, users of YouTube and subscribers to the Bible Reloaded were no longer permitted to access and watch the first video. The detrimental effects of the first notice were realized immediately, aside from the fact that plaintiffs were forced to expend extensive time and effort responding to the notice. The first video was not publicly accessible for 6 days. As a result, plaintiffs were deprived of a significant amount of advertising revenue from the performance of the first video. Furthermore, due to the video not being accessible, plaintiffs lost out on a significant goodwill and publicity associated with the release of the first video. During the first few days of the release of a video, YouTube videos commonly receive their most views, comments, and shares on social media. A successful launch of a video is key to its long-term performance. Additionally, during this period, YouTube prohibited plaintiffs from uploading new videos longer than 15 minutes, affecting the majority of their videos and causing an estimated loss of approximately 120,000 views. Because plaintiffs were not allowed to upload videos longer than 15 minutes, they were also unable to participate in live stream fundraising events on the website patreon.com. The damages caused by defendants' submission of the first DMCA notice is irreparable and is still being suffered by plaintiffs. On April 21st, Jake contacted CFG by means of CFG's Twitter account and was immediately banned. Plaintiffs communicated through email with defendants regarding the first DMCA notice. Plaintiffs advised defendants that use of the still shots and brief video clips was in a limited capacity for the purposes of review, and such use of a copyrighted work is protected as a fair use. While defendants adamantly refused to retract their first DMCA takedown notice, the Bible Reloaded published another video, a 13-minute, 15-second video, entitled Hey Scotty, Lawsuit Man. Due to the restrictions, it could only be 15 minutes long or less. The second video does not contain any still shots or video from any of CFG's motion pictures. Following the release of the second video, plaintiffs received an email from Dave praising the publicity that the first video had brought to CFG's motion pictures and mentioning that another person is doing the shutdowns for us. That other person was later identified to be Salvanayagam. In subsequent emails and in response to Hugo explaining to Dave the doctrine of fair use, Dave agreed that this all makes sense and stated that he had asked Salvanayagam to revoke the first DMCA notice. Hugo also exchanged several emails with Salvanayagam on this same day concerning retraction of the first DMCA notice. On April 26th, the copyright claim was retracted. On April 27th, plaintiffs published a 36-minute video, How We Got Our Groove Back, In the third video, plaintiffs solely discussed what had happened in the first video and the first DMCA notice. The third video does not contain any still shots. Between May 20th and June 24th, plaintiffs published 3 additional episodes of the Bible Reloaded, offering criticism and commentary about different CFG films. On May 20th, they go over that these do not contain any of the video content, they only show still shots. Despite this, defendants' attempts to silence plaintiffs' critique of CFG's motion pictures was far from over. On August 15th, plaintiffs were again notified of another round of takedown notices. Defendants claimed the 4th, 5th, and 6th video infringed copyrights. Those claims are frivolous, as those videos contain only still shots and are protected by the fair use doctrine. Equally concerning, plaintiffs were notified by YouTube that the DMCA takedown notices were also issued against the second and third video. In these videos, plaintiffs only discuss the takedown, and they do not contain any shots whatsoever. On information and belief, defendants knowingly and willfully falsely claimed in a DMCA takedown that the second video contained infringing use of the motion picture Second Glance. This was an outright lie. In fact, Second Glance was never mentioned in the video. So, their first claim for relief is a DMCA misrepresentation. So, just a refresher course, the DMCA contains a provision that when you issue a takedown as a plaintiff, you are certifying that you've done your due diligence in making sure that you have the right to file that takedown notice, not just that you want to take something down, but you, under penalty of perjury, declare that you have the right to. So a violation of that is a violation of a section of the DMCA that enforces that. It's Section 512F of the Digital Millennium Copyright Act. It basically says that it's an actionable thing to sue someone over a misrepresentation like this. The second claim for relief has been filed as unfair competition. This cause of action is brought under the unfair competition law of the Professions and Business Code. I'm assuming that is a state law. Yep, the California Business and Professions Code. Flagrant abuse of the DMCA takedown provisions violated defendants' copyrights in an effort to stifle plaintiffs' free speech. Defendants' intentional misrepresentations constitute unlawful, unfair, and fraudulent business acts. Plaintiffs have suffered and will continue to suffer irreparable injury not fully compensable in monetary damages and are entitled to injunctive relief as well, and punitive damages. So they claimed compensatory damages, injunctive relief, and punitive damages. Third claim for relief, intentional interference with contractual relations. So they're saying here that by filing these false DMCA takedown notices with YouTube, then that interfered with their rights and agreement with YouTube because they got limited to 15-minute videos and might have lost monetization on that one video, etc. So they have asked for actual damages pursuant to the DMCA, a declaratory judgment of non-infringement, injunctive relief restraining the defendants from bringing any lawsuit, submitting any DMCA takedown notices, or issuing threats against the plaintiff, damages for intentional interference with contractual relations, punitive damages for malicious and fraudulent abuse of the DMCA, punitive damages for malicious and fraudulent intentional interference with contractual relations, punitive damages for defendants' unlawful, unfair, or fraudulent business acts in violation of Business and Professions Code, attorney's fees, costs, and such other and further relief that the court shall find just and proper. So, very interesting. So then they made the video about it and said that they were going to sue. And then apparently went about the act of suing. They set up a GoFundMe page here and have raised so far $84,000 of their $100,000 goal. Their page reads, "Hello everyone, this is Hugo and Jake. We need your help. As you probably know, we've had false DMCAs thrown at us nonstop for months. Recently, the Cristiano Film Group falsely DMCA'd us for 5 different videos. We've had enough. We're fighting for our channel. Here's where you come in. We have contacted the Fair Use Protection account, which was spearheaded by H3H3 and YouTube. We got a hold of Michael Lee, and he gave us the following numbers. $5,000 to start. This gets us a lawyer on retainer. They can begin to process the process of getting the suit served, negotiations, and other preliminary things necessary. We need this ASAP. $50,000 halfway. Halfway point, as copyright cases are far more complicated than they seem. And don't we know it? $100,000. This should be, unless for some reason, cover every possible expense, including possible and probable appeals, more lawyer fees, more travel, etc., etc., etc. According to our conversation with Michael, we have an incredibly solid case. The problem is, sadly, we're atheists making crass remarks towards a Christian film company. That is the sad reality. It's entirely possible to get a religious judge that doesn't side with us. That said, we are confident, yada, 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 yada. Hugo and Jake. Great. So, back to the lawsuit. They filed that complaint on October 3rd, 2016. There were a bunch of things that had to be done to get Michael Lee, I think his name is, pro hoc viced into California court. And then we get down to here at the bottom. November 2nd, first stipulation extending time to answer the complaint as to the Cristiano Film Group. That looks like this. Defendant Cristiano Film Group has until November 2nd to answer or respond. Pursuant to a local rule, the parties and their respective counsel agree to a 30-day extension of time. So then, on the 29th of November, a notice of voluntary dismissal gets filed by the plaintiff. That looks like this, just in case you're wondering. It's just a form. This action is dismissed by the plaintiffs in its entirety. Signed by Michael Lee. And that's it. I haven't been able to find anything else about the case since then. But the GoFundMe is still up and is still running and is still collecting $85,000. So I'm kind of wondering what's going on. So I asked around and did some searches and sent some tweets and things, and some people responded. And I came up with this. This is what I was able to find. Someone posted this screenshot to our Discord server. And this looks to me like the Bible Reloaded wants to talk about the case, but is currently getting permission to do so. And I'm not sure when that will happen, so let's put away the pitchforks for the time being until we see what their response is to what's going on with the lawsuit. Because I don't know, they raised $85,000. Is that money going to get donated to the FUPA? Are they going to keep that money? Did they use that money for this 2 months worth of work? We know that we saw some big bills from H3H3. So I think some people maybe deserve some answers. And so that's why I thought I would ask some questions. Now, it's entirely possible that after filing such a strong case, the Cristiano Film Group and their attorneys took a look at the case and thought that it was also a bad case for them to try and fight. And so they decided to settle the case. The problem is we don't know what the terms of that settlement are. That's probably very private. There's probably going to be some kind of confidentiality agreement so that both parties don't talk about the terms of the settlement itself. So we probably will never know how much money was exchanged, if any money was exchanged at all, if there were additional terms to the agreement, unless the Bible Reloaded are allowed to speak about those with permission of their attorney and possibly the other attorney, if there was some kind of confidentiality clause to that agreement. So that could be what happened here, and I'm looking forward to hearing from someone who really knows what's going on. So thank you for watching. I would also like to thank Joshua Meinzinger and John Cripps, who are currently pledging to the channel at the $50 level, and thank you to the $5 plus Patreon supporters that are currently scrolling on the right side of the screen there in my little LED panel. All of your support, all of my Patreon supporters' support is very much appreciated. You're really helping take some of the financial burden of this channel off of me, and that makes it easier for me to spend time creating the content. You really want to be able to focus on the things that are important. So that's really helping, and I really appreciate that. Also, we have a fledgling podcast. Sarah Bjorklund, Skeptic Sarah, and I have been working on a copyright podcast, and so far we have the first episode out, and I'll link to that in the description below. It's on iTunes and other feeds and things like that as the Lawful Masses Podcast. Lawful, Lawful, Lawful Masses Podcast. Lawfulmasses.com is where you can find that, and I'll put information in the description below. So thank you all for watching. I'd love to hear your comments and your thoughts and your concerns about what's going on with this lawsuit, because I don't think anybody really knew that this lawsuit had been dismissed unless you had literally gone onto the court docket and looked and seen the November 29th filing of the voluntary dismissal. So thank you for watching. I'm Leonard French, your favorite copyright attorney, and have a great day.